There was a recent case that was put out by the California Court of Appeal, and it's called Coito versus Superior Court. It was recently published, although it came out back on March 4th here of this last month. The reason this is important for attorneys, at least, is because it tells you a little bit more about how you should conduct your interviews of third-party witnesses, as well as how to respond to the Judicial Council-approved form interrogatories. So just to give you a little background on the case, there was a 13-year-old who was part of a drowning accident, and there were 6 people who witnessed the event. 5 of those people were noticed for deposition in the subsequent civil lawsuit involving the drowning. And of those 5 people, the one party decided, you know what, we need to take some witness interview statements of these 5 and find out what they're going to say at the deposition. So they actually ended up getting 4 of them to give a statement. When they gave these witness interview statements, the one party got them but did not turn them over to the other side. And so at the first deposition that went forward, one party was able to question the deponent based on the statement that was given. However, the other side was like, well, wait, where's our statement? You didn't turn that over to us in discovery. So immediately following that deposition, they requested that through Judicial Council form interrogatories 12.2 and 12.3. And the other side says, no, you're not entitled to it. It's an attorney work product. We're not giving you our statements. They made a motion to compel. The trial court agreed with them, saying, no, it is work product. You're not entitled to give it to them. And that's what gave rise to this new Court of Appeal decision, in which the court said, any recorded statement, whether it be an independently prepared statement by the witness who just voluntarily gives it over, or whether it's taken by an attorney or an investigator, any type of statement, that is discoverable, and you got to turn that over. They gave some reasons, because it's either a prior consistent statement or prior inconsistent statement. It could be used to refresh recollection, a number of different evidentiary reasons why that is discoverable evidence. However, they said that the list of witnesses that you decide to interview, that is not discoverable. That is still comes under attorney work product production. So the important take-home thing for, I think, attorneys is, number one, is to remember that any statement you take of a third party could be discoverable and turned over to the other side. So the court even gave a tip that said, hey, look, be careful then how you even question a third-party witness, because how you question that witness could reveal your trial strategy. Just know that that's going to be turned over, so now tailor your interviews accordingly. The second thing is just to remember is that in case you have you do a memorandum. Very common for attorneys to do a memo after a witness interview, which basically describes, here's how I feel about that witness. He came across as a good witness, not a good witness. It's important to remember that your attorney opinions, what you felt about the witness, those type of things, that is still covered by the attorney work product protection. And so if you intermingle the facts from that witness as well as your own opinions or impressions, that is still work product. However, if there is a question about whether that independently recorded statement, those facts, is mingled enough with your work product, then you can always request an in-camera review by the court so that they can determine whether or not that falls under the work product protection.